proceed.
Your permission, Mr. Chairman and other members.
If it may please you, Mr. Chairman and honorable members, I'd just like to go on record about representation of the accused persons by first of all introducing myself, Lukwago Erias, as one of the lawyers. Mr. Chairman, we intend to address you on issues regarding the lead counsel, who is Honorable Martha Karua Wangari. She is a practicing advocate within the Republic of Kenya. And Mr. Chairman, she has got her certificate of practice, and she's in the process of securing temporary practice to be able to handle this case as the lead counsel. She takes charge of the entire legal team here and internationally. Other members, Mr. Chairman, for the record, Mr. Chairman, if I may pass on her documents to the judge advocate here. Mr. Chairman, we have my land friend. No, for the record, the Honorable Martha Karua is a senior advocate. She's a senior counsel. She has that title. We have my land friend Ernest Kalibala, who has been before this court since morning. We have Counsel Kiza, who is here. Nalukola Erias Luyimbazi, Ronald Samuel Wanda, Chintu Michael, Kato Tumusime, Iskakuru Tumusime around, Sekanja Kabubakar, George William Mukula, Sekade Julius, Kunihira Proskovia, Bayan Tulinawe, Mugaga Mukuve Karemire, Katushabe Ronald, Isaac Kwagala, Faruku Kamreke, is Kabuye Lawrence around, Ukato Wilson, John Mata Nsimbi, Cyrus Ogul, Tugume Moses, Akakimpa Godfrey, Muizi Samuel Mulindwa, Kijambu Gordon Mukisa, Tenderi Raphael, Retired Major Roland Iduri, and Enap Dennis Adim. I don't know whether there is anyone I've not introduced. So far, that is the team, Mr. Chairman and honorable members. But for the record, Mr. Chairman, Senior Counsel Martha Karua is still coordinating a team of lawyers from Kenya, from Nigeria, from Tanzania, Pan-African lawyers to be able to take charge of this honorable case. This honorable case, rather this case as our lead counsel. The unfortunate bit, Mr. Chairman and honorable members, since she arrived in the country yesterday, she has not had any opportunity as the lead counsel to interact with their choice department. This morning, right, Mr. Chairman and honorable members, we visited the office of the law counsel, and we had the opportunity of talking to the chairperson of the council, Justice Irene Muryagonja, regarding the process of securing a temporary practicing certificate as required under Section 18 of the Advocates Act. Unfortunately, she informed us that council is yet to sit and pronounce themselves on the matter. And as we talk right now, they are yet to finalize the process. The assurance she gave us is that they are going to expedite the process and that we may hear from her probably tomorrow or the day after. So that is the assurance we are given. We should be seized with all the tools and facilities to be able to take charge of the matter. And this is where we stand today. And this is critical in the dispensation of justice, Mr. Chairman and the honorable members. Wanted to bring that to the attention of this honorable court. With your permission, Mr. Chairman, I would like my colleague to pick it up from there, Ernest Kalibala, if you may. Most obliged, Mr. Chairman.
May it please court chairman and other court members, before we proceed to have a ruling of this court.
Excuse me, we are still proceeding. Please, you let us first finish our submission. Thank you very much.
Sit down.
We are still proceeding as defense counsel. We shall not allow you to proceed. Listen, as we are proceeding as a defense team, we have not finished.
Okay, let them finish their part, then you will reply.
So the council has no locus. This is what I'm going to talk about.
No. I have all the locusts.
I need the one you are introducing.
What are you talking about?
We are not for a fight.
So, Mr. Chairman,
it's their turn. You leave them, let the defense lawyers put up their...
Mr. Chairman, the prayer we are making, if we could be given time to interact with the chosen persons, considering the prevailing circumstances where we have the lead counsel who has that issue, who is incapacitated as of now. So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
Council.
I mean, Chairman and members of this honorable court, if I may put its point succinctly, is that the defense team requests this honorable court to talk to the clients, Besigye and Rotary, and then we get effective instructions on how to proceed, because this is not going to be business as usual. Thank you very much.
I wish, Council, you could reduce on your tune. That one has no problem. Council Road Mayor, what time do you want to talk to him now, or you want to talk to him any other day?
No, I want to talk to him right now, but in the camera, not in public here.
Yes, we can also allow that if it is not going maybe to take a long time.
Like 30 minutes?
Yes.
I think, sir, there are legal issues before you allow them. One, the lead council, you are saying she has no instructions as of now. So if she has no instructions, are you saying the case cannot proceed with all these other lawyers you have introduced? And if you are not ready until she acquires a certificate, then it would mean nothing can proceed. Either you seek an adjournment another date, but giving them the minutes still will not make a difference. Because he's saying he cannot proceed without their lead counsel, who is improperly before court.
Honorable Chair, I was very clear. The instructions given are to the effect that Honorable Martha Karua takes charge as the lead counsel. And there are some legal hurdles we have encountered along the way. It's his decision to take any other decision if he so wishes. So this is the matter. This is the issue we are raising. That if there is any adjustment to the instructions, we need to confer with him or with them. So the question is, all along we have been seated outside, we have not had any opportunity of interacting with him. So right now, that's basically what we are seeking for. Like 30 minutes, we agree. We decide on the way forward, we chart a way forward after having a conversation with him over these issues. I am sure he's just getting information about what we have been doing at the law council just right now here. We had not yet even briefed him as to the progress of the matter before the law council. And these are the issues we should be discussing with him.
And for the avoidance of doubt, that's why Honorable Martha is not yet speaking. We want to talk to the two clients so that they allow us, in the meantime for today, to proceed without Honorable Martha leading the team formally, because they may ask themselves that we chose Honorable Martha to lead and we see Lukwago and Karibara. No, so we are trying to consult them to make them appreciate. So for now, Lukwago and Ernest are leading, as you have seen, and they are requesting, the team is requesting to confer with the client for 30 minutes in the camera so that we can effectively represent them. Yes, thank you very much.
You can hear from state because he wanted to talk. They said he was within their time. Can you address court before the chair takes it serious?
Okay, Council Lukwago has introduced a battalion of lawyers, but among them, I think it is only 4 who have complied with Regulation 62 of Uganda People's Defense Forces procedures. That is paragraph 3. And those ones who have complied are Lukwago, Kiza, Narukora, and Masiko. So I think the rest should not be on record. Yes, they have not complied. Read the regulation. Unless they comply with this regulation, they should not be on record. Person is entitled to appear as advocates.
Order, please.
So I will simply go to paragraph 3. If an accused is to be defended at his court-martial, by an advocate not nominated by the convening authority, the accused shall give the convening authority notice of his fact not less than 24 hours before his trial. So it is only those four who have complied with that. Even the document, this document here, which is before court, it is as if it is coming from this court. It is a Republic of Uganda, Uganda People's Defense Forces in the General Court Martial, ordered at Machine. So this document does not bear the address. It is not
Signed by.
I don't know even if they want to pass the I don't know yet. So these people are not properly before this order of court.
I think, Councillor Lukwago, this goes back to what our judge advocate advised. Maybe to sort out these issues, you could pray for an adjournment and you clearly put everything right.
The prosecution is misleading this court. The instrument is reading was about law firms. It's not about the particulars of the individual advocates. Actually, where I was reading, my name is not there. It's Lukwago and the company advocates. If we cared enough to look at the list I was reading, he would see the individual advocates and the law firm they come from. They are indicated there. So this is the list. So there's a difference between law firms and individual practicing advocates. For example, Martha Karua on this list is care of Lukwago and the company advocates. And it is in black and white. So I don't know, his point is neither here nor there. To me, Mr. Chairman, it be considered as a very serious matter. And in any case, the lawyers are here. If you want their particulars, we can furnish them to court. They are here. So those are the things the Constitution intended to cure. Article 126. Maybe it's not applicable in this court. But if the Constitution is the fundamental law of the land here, it's very clear. Substantive justice as opposed to those minor technicalities, which are neither here nor there. So I don't think we should indulge in those gymnastics, Mr. Chairman.
These are not minor technicalities. Mr. Lukwago, you endeavored to attach your practice certificate. Kiza, you did. This is reimbursed did. And this is in compliance with the law. Why did you do this? So those ones who have not complied shouldn't be on. Why did you do it at your colleagues? Or why didn't you advise your colleagues also to do the same?
So I don't understand his prayer. Is he suggesting that the lawyers who are not on this list shouldn't even be here? I don't know the prayer he's making.
They shouldn't be on the record.
Yes?
They shouldn't be on the record. I think you have not appreciated the regulation. It is not my law. Read it.
I think I want to reiterate the position of the Honorable Mayor that my colleague in uniform is on a mission to mislead this Honorable Court. And he's doing well in that direction. If he had taken the time to read Article 28 of the Constitution, which I'm going to read for him, Article 28(1) guarantees the right to a fair hearing and guarantees the right to a lawyer of his choice and defense facilities. Article 44, paragraph C of the same constitution says that this right is not negotiable in my language, but in its speculation it uses English of non-derogable. Notwithstanding anything in this constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Paragraph C is the right to a fair hearing. The right to a fair hearing includes the two accused persons choosing their lawyer, which they have done. You can't tell them, even now they can appoint a lawyer. Now as we're proceeding, they can even fire us and replace us. That's fair hearing. That rule you are quoting is null and void. Article 2 of the Constitution is very clear that if any regulation, rule, speech from the prosecution is inconsistent with the Constitution, the words of the Constitution, Chairman and members of this court, is such a things as he is saying are null and void. That is Article 2 of the Constitution. Will this court follow null and void submissions, or will it follow the provisions of this Constitution? Thank you very much.
I don't know why my colleague has got the jurisdiction to pronounce the law null and void. Read Article 137.
Said regulation is not the law.
It is a law regulating the law. So where do you get the mandate? You Kiza.
I went to law school for 5 years, studied law, and this constitution was promulgated in 1995, and Article 221, these articles are in my head, says that UPDF shall promote, respect, and protect this constitution and the fundamental human rights of Ugandans. And we are saying the right to a fair hearing is not negotiable. And we are saying the right of Besigye and Rotary to choose their lawyers, even to change them, is not negotiable. So if you have not read those specific provisions, you shouldn't come here to mislead the court.
You should come when you are prepared.
I am prepared. That's why I'm reading the Constitution and you are reading the rhetoric.
Mr. Chairman, if I may, and I know I am perhaps one of the subjects of the objection, if the court will allow me to just address it. I think my learned friends have made very clear what the Constitution says. The right to appoint counsel is a prerogative of the accused. What the state is citing is an administrative process of notification, so that we tick boxes, we dot the I's, we cross the T's. But that is a technicality. And that same constitution, being aware that there may be instances of this nature, then requires that substantive justice is administered without undue regard to technicality. It's not a question of completely ignoring it, but it's undue. And perhaps there are practical ways of dealing with that administrative problem that the court has been made aware of. The accused are here. They haven't yet spoken and said that the list of people that was read here is a list of masqueraders. I believe they can confirm, if they are required to do so, that the list as read are their lawyers, so that we move on to something else. If there is a simple administrative matter that hasn't been complied with, it can be complied with in due course. If there is need to have a look at our practicing certificates,
thankfully, we have a practice of walking around with them for this very reason, so that we are then able to satisfy you that we are not here to spend the morning engaging in semantics, but we are here for serious business. I thank you, Mr. Chairman.
I think, sir, I have listened to all, both sides. One, there are two issues, and it is not yet resolved. The address of the lawyers who filed their PCs with court is General Court Martial, and I believe you have law firms where you practice law. So is this an authentic document? Who filed it before this court? Then two, if you say it is an administrative order, we don't want to be restricted in law. All of us studied the 5 years you took in school, we also took them. So when he's putting on that uniform, you should know that he spent the same years you spent. If you have attached your certificate, why have others not attached? And you cannot say that instructions, if they are in a law firm, yes, you can. Did you comply with the regulations and file within the 24 hours, which is required? So you cannot run away. Others have provided, and then you say there's no need to provide. Why did you comply and others didn't? So still, those who have complied with the regulations can go ahead and address court, and others also must either go on record and file instructions. If you want to challenge it and it becomes a constitutional issue, you can take it on from there. But that is my advice to this court, sir.
Most obliged.
So, Councillor Lukwago, are you ready to continue with that group which has fulfilled the instructions?
Mr. Chairman and honorable members, earlier on we made a prayer that we be permitted an opportunity to have an interface with our clients here. It's one of the issues we're going to address. If we may be granted that opportunity to discuss, all these issues are arising because of the fact that we have been denied access to our client. Even when he came in here, it was difficult even to wave at him.
But Council, how did you arrive at that number? Did you consult them or you didn't consult? It was your choice or it was their choice?
It was his choice first when we met him at Ruzira. And that was once. If the first time I went to Ruzira, I was denied access to him. I even talked to the Abasaija. And I told him I have a list of lawyers here. I want to finalize these processes. You can confirm this with the Commissioner of Prisons. They stopped me at the gate there. They stopped me from accessing the upper prison where he was. So what else did you want me to do under those circumstances? I was in charge. The lead counsel had not yet come into the country. So I generate a list as requested by him. I go to Ruzira to talk to him to see how we are finalizing the process of instructions. I'm blocked at the entrance. I seek for the intervention of the Commissioner General of Prisons, all in vain. Now I come here, they raise technicalities. I am asking this one, now that he's here, can I have a word with him over all these issues?
Is there any harm on that? Councillor Lukwago, you are given 30 minutes as you requested to interact with your clients as we proceed.
Your Honorable Court would like guidance on the provision for interacting with him, because we are not free to interact with him with all these other people. We need a private space where we can interact with Rotary and the Besigye and advise them on confidential issues that are protected by the lawyers-client relationship confidentiality issues. Thank you very much.
Use the other room, the first room, as you Or he can provide the space. This one. But I did not hear his name on the list. We are proceeding, and in case those who are behind, in case you want to move out, please go politely, either to ease yourself or whatever, and then you come back. We don't expect a commotion here. State, are they ready with Agama?